Good afternoon, everyone. Again, I'm Paul Friener. I'm a managing partner with our Tully Rinckey Austin office, and today I'm going to be presenting with my co-presenter, Jonathon Gonzalez, and he'll introduce himself. Just a little bit about me and my background so you understand a little bit about what we're talking about today and why the area of law that we are going to discuss is so important to kind of understand this intersection and overlap. So I primarily focus on employment and labor claims in the Texas side, which what we're discussing today, and also on the federal side. So if you're a federal employee and you're experiencing retaliation and harassment in the workplace, we are a firm that assists our clients with those type of issues. But today, my primary focus is to convey to you what happens in the Texas side of things. Jonathon's going to be talking a little bit about the military side of things, and he'll kind of explain that. But part of my practice is assisting people who experience employment discrimination, employment retaliation, and that is primarily what our clients come to us seeking assistance from. I have a background in working with employees in different contexts, whether it's unemployment benefits, being denied, your right to certain benefits as a Texas citizen. We help a lot of people appeal those issues. And so now focusing on the discrimination world, we work a lot with the EEOC and we work a lot with the federal and state courts in pursuing those claims. I'm happy everybody's here today, and I look forward to talking with everyone about Texas employment law. Jonathon, I'm going to turn it over to you. And you can go to the next slide.
Hello, everyone, and thank you all for joining us today. So as Mr. Friener said, my name is Jonathon Gonzalez. I'm an associate attorney at Tully Rinckey. And prior to joining Tully Rinckey, I enlisted in the Marine Corps, and I was in the Marine Corps for 10 years. Afterwards, I got my law degree, and I have been practicing military law since. I have done command managed equal opportunity complaints, and I've represented clients in that regard, and I've successfully advocated for clients to ensure that they receive some sort of justice for any sort of retaliation, reprisal, hazing that they've experienced. So thank you so much, and we could go on to the next slide.
Thanks, Jonathon. So Brittany already discussed a quick overview, but these are the topics that we're discussing today. The purpose of the way we designed this presentation for you today was we wanted people that are, potentially experiencing issues in the workplace. And, if you're a member of the military, that is your workplace. And so when we are dealing with issues of harassment and retaliation, those can occur in a lot of different places. They can occur if you work for a Texas employer, or they can occur in the military. And so because of that overlap, we believe this information is going to be helpful if you're experiencing that and both of those different areas of law apply to you. So you'll see some overlap, you'll see some similar language, and it's designed that way. The laws typically are followed and mirrored after other laws that are trying to protect people from this harassment and discrimination. And so you see that we have here cited the Title VII Civil Rights Act, but also the Department of Defense Instruction 1020.03. Both of those are involving and protecting people in their workplace. We're going to talk about how you file an EEOC charge. We're going to talk about how you file a CMEO complaint to your command. We're going to explain to you what the deadlines that are associated with those are, so you know if you are somebody who is fitting into these categories, how much time do I have? Do I need to take some type of legal action? And if if your questions don't get answered today, please reach out to us for a consult. These are areas of our practice and specialty, and we're happy to meet with you and talk about your situation specifically. But again, this is going to be general information. It's not tailored legal advice to anybody that's on the call today. So please kind of take that with a grain of salt, that what you're hearing is a maybe for you, and you want to come and talk to us to kind of confirm if it does apply to you. So first up, we have Title VII of the Civil Rights Act. The Civil Rights Act was designed to protect essentially from a federal perspective, but also, since we're talking about Texas today, but this is a federal statute, protecting people from discrimination in the workplace, protecting people from harassment in the workplace, and protecting people from retaliation. For harassment specifically, harassment is defined as the unwelcome conduct that is based on race, color, religion, sex, and it includes sexual orientation, gender identity or pregnancy, national origin, age older than 40, disability or genetic information, including family medical history. And so you always have to remember when we're talking about harassment, it's very different than this idea of my employer, supervisor, or even coworkers are bullying me because they don't like me. You come to work today and you're wearing, a new set of shoes, and your supervisor comes up to you and starts being mean to you because they don't like the shoes that you're wearing. Well, that has nothing to do with race, has nothing to do with color. Now, it could maybe under the circumstances have some type of connection that's indirect, and we always look for that when we're issue spotting with our clients. But generally, you have to have that connection in order for this to be a claim under the Title VII Civil Rights Act. Harassment becomes unlawful when enduring the offensive conduct becomes a condition of continued employment, or the conduct is severe or pervasive enough to create a work environment that a reasonable person would consider intimidating, hostile, or adverse. So it's all about meeting that threshold of offensive conduct, that you cannot go back to work because the harassment is occurring so frequently. You cannot continue to perform your job because the harassment has been so abusive that a reasonable person would also feel the same way. It's not just you specifically, that anybody that was experiencing that treatment from a supervisor or from a coworker would not be able to perform their job. That's unlawful harassment. Again, it can be different from what's just general harassment. And I don't want you to get confused, but again, you have to understand that there are a lot of different elements in relation to the definition of harassment. And at the very base, if you don't have a protected basis claim that's connected, like race, color, sex, you're going to have a very difficult time trying to be able to bring your claim. Some additional information: petty slights, annoyances, and isolated incidents will not rise to the level of illegality. Again, to be unlawful, the conduct must create a work environment that would be intimidating, hostile, or offensive. And so the most important thing that I think a lot of people should know about this slide is that an employer is automatically liable for the harassment by a supervisor. And they put that higher burden on supervisors because they should know. They likely will have received anti-harassment training. They will likely have signed some type of policy with their employer saying that I understand the rules of harassment and what not to do in the workplace and how to handle it if it's occurring. But if it's coming from your own supervisor, the courts in Texas, the federal courts have found that they have a higher threshold. They have a higher responsibility to their employees. And so they will be automatically liable. And the reason this is important is sometimes when you're experiencing harassment from a supervisor, you may not feel comfortable making a complaint against your supervisor, especially if you work for a small company and the person that you have to make the complaint to is the person that's doing the harassment. The reason, if you take that example and understand like harassment in the context of I'm being harassed by a coworker, well, there is a responsibility under the law to report that harassment to your employer, to report it to your supervisor. And then in that case, once you report it, the supervisor or the company has an obligation to take corrective remedial action against that harassing employee. And so if you never make the report, it's logical that the employer is not going to have any responsibility because they won't know about it. But when it's coming from your supervisor, you have sort of a shortcut there and they're automatically liable. Now, there's going to be situations, and we always get the question, like, going above the head of your supervisor and taking it to somebody else in HR. As long as you properly document that you've notified even your supervisor who's doing the harassment, you're going to protect your interest. So now let's talk about the nuts and bolts of it. How do you prove hostile work environment harassment? And you see that term hostile work environment with harassment often because that's how the courts have defined it. They consider this hostile workplace. A lot of people say toxic workplace. These things are all kind of interchangeable, but when we talk about harassment in the context of this presentation, We're talking about the type of harassment that where you belong to a protected class. So that's race, that's color, that's sex, disability, sexual orientation, that you're subjected to that same harassment. The harassment was based on the protected class, because sometimes you experience harassment and certain things that are happening to you may not be connected to your protected class of race, for example, or of religion, for example. It just may be other harassment. But if there is some harassment that is based on a protected class, then that fits in this category. The harassment has to affect a term or condition or privilege of your employment. A lot of times people have this internal conflict of, I need to work, I need to make an income, but if I go to work, I'm going to be harassed. That is affecting a term or condition of your employment. You cannot do your job, you cannot perform your duties because the harassment is impacting you. And then the last one is sort of a specific scenario. The employer knew or should have known of the harassment and failed to take remedial action. This could be an important element sometimes, because if an employer defends their case with, I never knew about it, and then we're claiming that, well, you should have known about it, this element will become highly litigious in the court system. And then it all, relies on who knew what and what kind of notice was given. And so that's why it's always important. And I always advise my clients, make sure you document the harassment and you document it in an email. You have a follow-up meeting, with your supervisor about those issues, and then you document that meeting afterwards. It will always kind of protect you later on if you have to go into court. A few additional notes about these elements. So the term sufficiently severe or pervasive behavior is required for harassment. Sufficiently severe means it's threatening or humiliating and unreasonably interfering with your work, kind of what you would think that something is extremely severe, opposed to somebody saying, your shoes are, I don't like how your shoes look. Now, a judge, maybe in a certain context, could think that that is sufficiently severe, but in general, likely not. Pervasive means the frequency of it. And the reason this is important, because harassment can occur over a long period of time. It can happen for years. And that really is important to know when it comes to determining, when should I file my claim? What's my statute of limitations? How long do I have to file that claim? And if that harassment has been by the same person, is continuing on and on and on, well, it's ongoing. And so that keeps continuing to push out your deadline of when you need to file. But the courts require that these types of harassments that are pervasive or severe be objective and subjectively hostile. So a reasonable person, not just you, would agree that this is harassment based on the law.
So I just really want to quickly talk about the differences between private employment and military employment matters. So one huge difference is that Bill of Rights and the Constitution generally does not apply, and so neither does Title VII of the Civil Rights Act. This Title VII of the Civil Rights Act does not apply in a military context. Okay. Also, you can't sue the military department if you're also a service member. You're barred from doing that. So, if somebody is harassing you, retaliating against you, you're experiencing reprisal, I mean, what do you do in these circumstances? Well, the Department of Defense has created an instruction called DODI 102003, and that governs, or that regulates how the military departments are supposed to handle allegations of harassment, retaliation, discrimination, and reprisal. So let's talk about, what is harassment? What is retaliation? What is reprisal? Well, harassment, unlike under Title VII, you don't need to be in a protected class. Okay, these could be anything. An offensive joke doesn't have to be racial. Okay, or it doesn't have to be sexist. Okay, insults, put downs, threats. Many military members receive threats from their supervisors, from their NCOs, racial slurs, hazing. We don't do blood stripes anymore when you become an NCO. these are all things that are detrimental to the good order and discipline of the armed forces. Okay, retaliation. What is retaliation? Well, it's an impermissible act by your chain of command as a result of you making a protected communication. So let's say you are getting harassed, right? And so you talk to your supervisors, you talk to your NCO, you file a congressional. Well, now your chain of command is taking action against you. You're getting a negative counseling, or you're made to dig additional sandbags in the field than everyone else. That is a form of retaliation. Now, it is different than reprisal. Retaliation and reprisal do have a small nuance difference in that reprisal is threatening or taking unfavorable personnel action. So, for example, an NJP, a negative evaluation. Those are unfavorable personnel actions because they impact your ability to promote or to be retained in the military departments. So DODI 102003 is a lot more broad, although you don't have all the protections, all the federal protections under Title VII. DODI is a lot more broad. You don't need to have those. You don't need to be in a protected class, and there's a lot more instances where you can actually file allegations of harassment and retaliation to your command managed equal opportunity officer.
So I can jump back in actually. And so this slide is connected. Brittany, if you'll go back to the original Title VII retaliation, I think it's about 2-3 slides. There we go. Thank you. And sorry for the jumping around. So talking about retaliation. So we already kind of know about harassment, and you just heard how the military interprets harassment. But what about retaliation? And so you kind of just got some examples from the military side, how retaliation and reprisal are looked at differently and how there's different nuances to it. But it seems to be there's like broader protection. For the retaliation under Title VII, it's very specific, and here's why. So the general rule is managers and supervisors must not retaliate against individuals who invoke their legal rights to file charges, which is the formal document letting the federal government know that your Texas employer is discriminating or harassing you based on a protected class. So when you invoke that legal right to file that charge, or if you support somebody else, like one of your coworkers or somebody that's in your workplace who has their own claim, and they've asked you to come and testify them or provide an affidavit for them, you're still supporting somebody else's cause of action, somebody else's legal claims. And the purpose of this Civil Rights Act statute is to protect you as well when you're helping somebody else, because they want to encourage people to come forward and make those claims. Title VII of the Civil Rights Act states that an employer may not discriminate against any of the employees because the employee has opposed that unlawful employment practice, or because the employee has made a charge, testified, assisted, or participated in any manner in any investigation, proceeding, or hearing under this act. And so it's a very broad definition of how you could be helping another employee. And so if you experience retaliation because you're helping one of your friends who's a coworker of yours with a EEOC claim, and you feel that you've now experienced this type of retaliation response from your employer, you would be bringing your own charge of discrimination in regards to having helped somebody else. And so when you're helping somebody else in that context, you should know what is their basis that they're being discriminated or harassed about. Because when you claim retaliation for your own case, they might ask you, well, what was that case about, and why do you think it was retaliation? Again, like they have to prove their own prove their own discrimination case. But when you are helping them, you have to show that you were helping somebody with an actual discrimination case. And then, Brittany, can you jump to the Texas retaliation slide about 3 slides down? There we go. And so there is a sort of a 2-step, 3-step process. There's 3 elements, but I've kind of cleverly called it the Texas retaliation two-step connection to help people remember this. Step one, protected activity. Step two, adverse action. And everybody knows the two-step in Texas. If you don't know the dance, I'm still trying to learn it. This will help you remember. So step one in the protected activity column, what is protected activity? Well, here are some examples. Filing or being a witness in an EEOC charge, complaint, investigation, or a lawsuit. Communicating with a supervisor or manager about the employment discrimination, including that harassment. Answering questions during an employer investigation of the alleged harassment. An employer may come to you to try to investigate some type of claim that your coworker has brought or that you have brought. And just by you answering those questions, if you experience some type of adverse action retaliation, then you can see how this would all fit together. Refusing to follow orders that would result in discrimination. That's kind of self-explanatory. You're not going to be asked to do something that's discriminatory. Resisting sexual advances or intervening to protect others. Requesting accommodation of a disability. When you request a reasonable accommodation under the Americans with Disability Act because you're not able to perform certain aspects of your job, that is a protected activity, making that request. And then lastly, asking managers or coworkers about their salary information to uncover potentially discriminatory wage. So a lot of cases that we help people with are wage disparity claims where you are making less money than somebody else where you should be making as much or more based on your experience. But because of maybe your gender in this case, which is the most common claim for this, you're not getting paid equally. All of those communications and conversations that take place, you can see they're all based around this idea of reporting something and having a conversation. That's protected activity. The law protects people to have those conversations. But after you have those conversations and report that protected activity, what if you receive adverse action from your employer? What does that look like? So step two under adverse action, for example, depending on the facts, it could be retaliation where you receive a reprimand from your employer, or you're given a performance evaluation that is lower than it should be. All of these things affect the terms and conditions of your employment. If you get a bad evaluation, you probably won't get the bonus. You could maybe, receive a counseling later that could lead to this and to that and to possibly dismissal. All these things are connected. They all have to do with you performing your job. Being transferred to a less desirable position, being engaged. So essentially your supervisor talking verbally or physically abusive towards you, or not talking physically, but acting physically abusive towards you, threatening to make or actually making efforts to making reports to the authorities. So if you do not have lawful status here in the United States, but you're working maybe on a work authorization card and your employer is threatening to call immigration services, call ICE on you because you're not willing to do something or because you took protected activity, that could be an adverse action for obvious reasons. There's increased scrutiny. So your supervisor just every day are micromanaging, making it very difficult to perform your job, spreading false rumors about you. The ultimate concept here is they're affecting the terms and conditions of your employment. It has to reach that level. A lot of times this type of adverse action concept can be litigated because the courts have defined what adverse action looks like, and courts are sometimes split on what that definition looks like, and it can be very dependent on what type of work you perform. The last element of retaliation is this concept of casual connection, and that's how the courts have defined it. There must be a casual connection between step one and step two. So to prove retaliation occurred in the workplace, the employee must prove there's a casual connection between protected activity and the adverse employment action. And you might be wondering, well, what is casual connection? What does that look like? How do you make that connection? The two biggest and most common ones that are used are temporal proximity and knowledge of the protected activity by the offending official actor. Temporal proximity means that the moment that you made that protected activity, that you had that communication about some issue in the workplace, the next day you were terminated. There's just a big inference that can be made when you were working fine in your job. You had no issues. Your supervisor liked you, but the moment that you made that complaint, all of a sudden you've lost your job. a judge would find there could be no other reason but for you making that protected activity that you were terminated. There's a very close temporal proximity to those two instances occurring. And then knowledge of the protected activity. If your employer knows that you made a protected activity complaint, and then all of a sudden you get fired, maybe a couple months later, and the same person that you made the complaint against is the person that fired you, there's a very strong likelihood that their knowledge of your protected activity impacted and influenced their decision to take an adverse action against you. That one can be a little bit tougher, and sometimes you need a little more details to prove there was a connection, but that is still a possibility. Just a few additional notes, kind of more of the advanced aspect of this. The adverse action must be materially adverse, such that it would dissuade a reasonable employee from making a discrimination complaint. The whole idea behind protected activity is we want to encourage people to make these reports, to engage in that protected activity. And if you're being retaliated against, the court systems and the Civil Rights Act wants to protect you. But the adverse action that's happening to you has to be material. So it has to rise to that level of a higher significance. But the whole idea is that we don't want to make people have to have this fear that if I report something, they're going to retaliate against me. And so that's why this law was created, to protect people while going through that process. And then note too, in some cases, and this is where it gets kind of frustrating, the Texas courts have held that reprimands are adverse employment actions, and in other courts, reprimands do not rise to the level of an material adverse action under that step 2. So that's why it's good to talk with an attorney and look through the surrounding circumstances of the adverse action, and as well looking at the defining case law for Texas, and that whatever's coming out of the Fifth Circuit, which is our binding court of appeals for Texas. That will help us make a better decision and help you define whether the adverse action you're experiencing is material or not. So now let's get into the procedures for both the employment and the military side of things. On the employment side, if you have a claim of harassment or you have a claim of retaliation, how do you file an EEOC charge? So the EEOC charge is the formal document that we file to bring a case in front of the EEOC and hold the employer accountable. And we've already gone through the different protected bases for them. And so a charge of discrimination can be completed through the EEOC public portal or at any of the EEOC's 53 field offices. It won't be something that you'll have to worry about. It'll be wherever you're physically located, the EEOC will assign your case after you've submitted an online portal. If you're working with an attorney, there's an attorney side to the EEOC portal that we would file that for you, and they would typically assign it to the proper office with the proper field office employee. A lot of times when it comes to filing, the big question comes up, well, I know I have a case, but is it too late to file my case? And we'll talk a little bit more about this, but in Texas, you have 300 days to file your EEOC charge. In the United States, generally the rule is 180 days by federal law. In certain states, it's 300 days. And in Texas, Texas is one of those states that has a 300-day rule. But the thing to keep in mind here is, what if you're really close to the end of the 300 days? Well, as long as you file it within those 300 days, you're going to preserve your right to bring this case. The EEOC has a policy rule that if you have 60 days or fewer in which to file a timely charge, the EEOC public portal will give you special directions to quickly provide necessary information to the EEOC and how to file your charge quickly. As long as you file your charge and it's a formal filing process that you follow, the 60-day doesn't necessarily apply. The only time 60 days apply is because when you reach out to the EEOC without an attorney for the first time, they will preliminarily investigate your case, and you will maybe be confused. Did I file my charge because I told them about my case, or are they just going to schedule me for an interview? And so that's what we call an inquiry. And if you could jump to the next slide. So that's what the portal looks like. Nothing special there, but this is where you would start if you're going to file it on your own or without an attorney. So this is where you would log in and register your own username and login so you could access your own case after you create one. I just wanted to give you all an image of that. But my point is, an inquiry is not a charge. When the EEOC is doing a preliminary investigation of your case, they will tell you, we're going to schedule an interview with you on a specific date 2 months from now. That inquiry is not always going to preserve your rights under the 300 days rule. And you might be, concerned, if it takes forever for me to get an interview and I passed my 300 days, is this going to, cause a statute of limitations issue? And that's where that 60-day rule applies. You can select certain options for people who don't have attorneys that you want to indicate to them, I need y'all to speed this up. I need to file my formal charge right now, and they will help you with that process. Ideally, it's, or the whole purpose of that is to help people who don't have attorneys and go through a more kind of without the law aspect of things, just filing something so you have it on the record. But know that when you're making an inquiry, you have not filed a formal charge. You have not preserved your rights at that point in time. So the last thing I'll say about the portal and filing a charge is you can always, once you file your formal charge, whether with an attorney or without, you can check the status of your case regularly. It goes through the intake, mediation, investigation, and sometimes conciliation stage. And we're not going to get into the specific nuts and bolts. That's not the purpose of the presentation today, but just know that when you file a charge, there is a possibility that you'll have mediation where the two parties will come together to discuss the claims and try to work out a resolution. If the EEOC is not able to help encourage and facilitate a settlement negotiation, then you kind of have to hope that you're able to prove with enough evidence, if you're not working with an attorney, that your EEOC investigator will make a finding and then move your case to conciliation. And that finding could be there's a reasonable belief that discrimination occurred based on the facts that were presented. It's sort of like a probable cause finding that you would see in a criminal context, but they do it with the EEOC. And it can help vastly improve the chances of you reaching a settlement. There's no guarantee, of course, through all this process, but when an EEOC finding has been made, a judge will learn about that later on, and that could greatly influence a judge's decision that somebody who works for the EEOC believes that there is discrimination occurring because you presented a strong enough case. The judge may be influenced by that and also think that the evidence matches what you're saying when you're making those arguments in court. Ultimately, just one last thing on mediation is it's a voluntary process. We can't make the employer come to the negotiation table. So if they're not willing to negotiate about the legal violations because they believe there were no legal violations, there's not a lot you can do. And your only hope is that the EEOC investigator will be persuaded by the arguments that you're making for your case.
All right, so we're going to jump into the military aspect of on how you file a semio complaint. I just really quickly want to touch on one thing about harassment, reprisal, and retaliation, and that is under the DODI, harassment has to be objective. Okay, so it's not subjective, right? It's an objective standard. What would a reasonable person believe that you're experiencing harassment? Okay, so that's one thing that I wanted to talk about there. Now, how do we actually go ahead and file a semio complaint? What are the timelines associated with that? And who do you file with? Well, your command is going to have a command designated equal opportunity officer. Okay, all right. So that is going to be someone who's appointed as the equal opportunity officer by your commanding officer. Okay. Now, if you want, there's two ways that you can file a semio complaint. Okay. You could go the informal route or you could go the formal route. Now, filing an informal complaint does not necessarily mean that you go directly to the semio. You can go to you can solve this within your chain of command. Okay, so this is at the lowest level possible. All right, maybe you are experiencing some sort of harassment by your immediate supervisor. All right, let's say you're E3 and you're experiencing harassment by, your sergeant or your corporal, well, you could go to your platoon commander, you could go to your staff NCO. These are alternative individuals that you could go to that can help resolve these issues that you're experiencing. Okay, but what if that doesn't work? Or what if, this is an officer, or let's say it's a staff NCO who's actually harassing you? Well, then you want to file a formal complaint with the SEMIO, and it's going to go directly to your commanding officer. Okay, so how long do you have? Generally speaking, you have about 60 days from the time of the incident to file a complaint. Now, there are exceptions. For example, if we're talking about a series of events, right? A series of events where you were experiencing harassment for, months, right? Let's say I had a case where a service member was experiencing harassment by his staff NCO for about a year. And so long as it's a series of events, all right, and the last event is within the 60-day window, then you can file a SEMIO complaint. And you can add all those previous allegations in. Okay? Now, there are going to be nuances on exactly how you file it. For example, in the Navy, you have to use a NAVPERS. Okay? So in every branch, it's going to be a little bit different on, just on exactly how, on what piece of paper you're going to actually file this on. Okay? Now, once you have submitted a complaint to your commanding officer, how long did your commanding officer have to take action? Well, usually from the time that they've received it, they have about 5 days to speak with you and decide what they're going to do. Okay, whether they're going to initiate an investigation or whether they're not going to accept your complaint, which is something that can happen. Your commanding officer can take the complaint and think that nothing bad has happened because he believes that maybe, or he or she believes that the reasonable person standard wasn't met. Now, prior to initiating an investigation, okay, the commanding officer has a lot of latitude and a lot of leeway and authority that they can exercise. Okay, they can issue no contact orders during the pendency of the investigation. They can, for example, even contact your supervisors and issue direct commands to your supervisors. Don't contact you. Maybe you're mustering a certain way that's differently than everyone else. Well, he can tell your supervisors to cease any sort of harassing behavior that they might be involved in.
So again, coming back to these deadlines, I would say deadlines in the legal world are the most important thing. You have to understand, if you have a case, can you still file the case? And I kind of already touched on this, but again, Texas has the 300-day option. Not every state does, but Texas generally, wants to give people as much time as they can, and it's thanks in part to the EEOC for being able to, open that door for Texas employees. What's also important about kind of understanding deadlines is just really understanding the process too. When you're going through the EEOC process of their investigation, you might be wondering, well, what's the status of my case? It's been many months. Well, here are some things to kind of generally understand so you know what to expect and if you're going to be waiting for a long time. After you file your charge, within 10 days, the EEOC will send notice of your charge to your employer. And that is really important to know because, you may start to notice your employer acting differently towards you. Well, we don't want that, and the courts do not want that, but it happens. And what you should do to make sure that you're protecting yourself is document the change in behavior. Document any additional adverse action that's coming your way, because that could be considered retaliation. And if you've already filed your charge of discrimination and it's making its way through the process, and now you're receiving additional retaliation, well, you can amend your original charge and add that information there because you experienced a bad evaluation after you filed your charge. You experienced, being suspended without pay after you filed your charge. Well, now you're going to add that in there and they will receive that. Generally, a case investigation with the EEOC takes about 10 months. That's not a hardline rule, but that is what the kind of circumstances are, considering the amount of cases that people file every year. Now, you don't have to wait 10 months. You have the right to request what's called a right to sue letter. And the most important thing about understanding in what a right to sue letter is, a right to sue letter is when the investigation ends. There's typically 180 days that it takes from filing to the finish of your investigation. Sometimes it can go longer and sometimes it can go shorter, but there is a minimum amount of 180 days that they are allowed to have. Now, at the end of their investigation, if no finding has been made that discrimination occurred, that the EEOC is not going to conclude that there isn't investigation, but also the EEOC is not going to conclude that there is. So where does that leave you as the employee? Well, what you have just done with the completion of the investigation is you have what's called exhausting your administrative remedy. The courts and federal law requires that you exhaust your administrative remedy in going through the EEOC process after filing your charge and trying to mediate and potentially working on a settlement negotiation. If none of that has been productive and nothing of that has occurred, that right to sue letter essentially now gives you permission to file your case in federal or state court. And that's where that deadline can sometimes become important. And again, different courts have different judges. There's a lot of different factors on where you might want to file your case. But that's what the right to sue letter does. Some other things, I guess, if you're counting days, this is just kind of a small note that if the end of a deadline falls on the weekend, if, for example, you have to submit a rebuttal to a position statement, which we didn't really talk about, but a position statement is when the employer is refusing to negotiate, they don't want to mediate the case, the investigator gives them an opportunity to submit their position, a position statement on the claims that you've presented. And they will typically either say that we don't believe that there's any substantiation to these claims, or they'll provide some type of explanation or business justification as to why they're responding the way they respond. If there was any type of issue where they believe that discrimination occurred, that probably would not show up in a position statement. So most likely it'll be somewhat of a denial of your claims. You'll be given an opportunity to submit a rebuttal to that position statement where you're going to explain to them the facts of your case and how it supports your discrimination, harassment, and retaliation claims. But after the position statement and rebuttal are due, in the context of what we're talking about, if it is due on a weekend, that will roll to the Monday because that's just how the federal court systems work, and that's how these federal rules are applied. And just to reiterate again, if you think that you are going to run up against the deadline of when you need to file, if you haven't spoken with an attorney, just go ahead and file. File something and preserve your claims within the 300 days, and you can always go back and amend things so long as they're not too old. But you want to get something down on paper and you want to get something submitted to the EEOC, because if you want to eventually make your way into court because you're not able to reach a productive settlement through the EEOC process, then the first argument that an employer is going to make when you reach the court system is that your claims were untimely. And sometimes the interpretation that the courts use versus what the EEOC uses can be different. and not always favorable to the employee that filed it so late. So be aware of the rule. That's the first thing you should always kind of keep track of when you're starting to assess with yourself about whether or not you're experiencing retaliation, whether or not you're experiencing harassment, and you want to bring a claim. Do the calculation, do the math, and figure out, okay, what's my last deadline that I could potentially file something? And if you're not sure, I encourage everybody to talk with an attorney. There's a lot of exceptions to the rules that we're not able to discuss today. There's a lot of different things that we can help people with under different circumstances. But if you're wanting to just at least figure out, do I have a case and what would be the steps forward? Come talk to us and we can help you figure that out.
All right. So what happens after you file a complaint, right? So I had touched on it previously before. Your command can initiate an investigation. So let's say your commanding officer does accept your semio complaint. Okay, what he or she will do is appoint an IO, which is also known as an investigating officer. That's usually an officer within your command to investigate your allegations. Okay. Now, the IO usually has about 36 days to investigate. However, there are extensions that can be granted. Okay. For example, let's say you had about 20 witnesses that you put in your complaint, and now the IO has to interview 20 witnesses. Well, after the 36 days is up, then the IO can continue to conduct their investigation without issuing a formal report, but they have to talk to you every 14 days. Okay, they have to give you an update every 14 days after the 30-day deadline has occurred. Now, these are a lot shorter than what Mr. Friener was talking about, where the EEOC has about 300 days. These deadlines are a lot less. Okay, and it becomes even more less with regards to sexual harassment complaints. Okay, the IO has 14 days to investigate a sexual harassment complaint, and your commanding officer has up to 72 hours to determine what they're going to do for a sexual harassment complaint. Those are treated a lot more seriously than your average harassment, hazing complaint. Now, at the end of the day, after the IO has conducted their investigation, they're going to finalize and issue a report to the commanding officer along with their recommendations. Okay, so one of the recommendations can be punitive action or administrative action against the harasser, or they could recommend no action because they didn't find any evidence of harassment. Okay, these are just recommendations, and your commanding officer is the one who has the last say. Okay, now let's say, for example, your commanding officer doesn't believe that there's any harassment that occurred. Well, just because they have the last say doesn't mean that you don't have a way to appeal your commanding officer's decision. There are ways that you can request a higher level review. Okay, so first and foremost, without getting too much into the weeds, you can submit a formal complaint to your commanding officer about any action they took against you. This is called a complaint of wrong. You can also request IG intervention. And you can also file a congressional complaint. These are all different types of ways that you can appeal your commanding officer's decision if you don't like it. Okay. Now, on the other hand, let's say there is a finding of harassment, retaliation, reprisal. Your commanding officer has a lot of authority. They can take punitive action They can't take administrative action, punitive action being court-martial, administrative action being Article 15, NJP, letter of reprimand. And these are all different ways that you can help resolve your semio complaint and protect yourself. Thank you. That's all I have.
So now we're at the portion of this presentation where we can answer some questions. People had an opportunity to send questions in advance of the presentation, but we're also, we have the time right now. If anybody has some general questions about the presentation that we've discussed that you want to issue in the chat, if you email them, we could try to catch them real quickly. We have some time right now, so we're just going to look into that and see if anybody has any questions that they want to submit. And then Jonathon, is there anything that you want, any questions that you've seen so far you want to touch base on?
Yeah, so there was one question about, how do you know when to go to the Inspector General or go and file an equal opportunity complaint? So Inspector General, they investigate waste, fraud, and abuse. Okay, if you are experiencing harassment, retaliation, if you're being hazed, if your NCO is putting you down and calling you all types of derogatory names, well, then you want to file an equal opportunity complaint first. Okay, and you might want to go the informal route first. Commands like to see you exhaust all of your administrative remedies prior to jumping the gun. So you might want to go with the informal complaint first, then go with the formal complaint. And if all else fails, then you might want to go to the IG. But first things first, you want to go file an informal complaint.
That's a great point. It's a great strategy too, kind of looking at all your options and giving yourself the greatest chance of trying to work out something that would be beneficial to you in some type of resolution. So that's a good example of using all the different things that we talked about today. Is there any other questions, Brittany, that you see that were shot to you in the last couple minutes?
Nope, I think those were all the questions that we had.
Okay, well, we really appreciate everybody listening to us today about what we discussed. We're very passionate about this area of law. We are a full service law firm, but if you have an issue that you want to come and talk to myself or Jonathon about, please feel free to reach out and set up a consult. We have many consult attorneys on the military side and on the employment side. Jonathon is a New York licensed attorney. He practices military law. He also assists me with some employment issues. I'm a Texas licensed attorney, also licensed in Tennessee. And then my primary practice is, employment law and labor issues. And so coming to talk to us, we can give you that tailored advice that will give you peace of mind, give you an idea of what you should do before your deadlines pass. And so I think that whether or not you believe you have a case or not, it's always just a good measure to talk with an attorney and determine, what's going on with my legal situation and do I have some remedies that I could pursue. So this question, I think I understand what it's asking. If it's Texas-based question, after being harassed sexually and racially, would such conditions allow the EEOC actions in another state? In Texas. So I think what the question is asking is that and I apologize if I'm misinterpreting it, but if the incidents of the harassment or the discrimination are occurring in a different state, can you bring it in Texas, or vice versa? If it's occurring in Texas, can you bring it in a different state? That's a great question. That has to do with the venue of maybe ultimately where you would file a lawsuit. But when you're going through the administrative process, it typically will come down to where your employer is located. So I've represented remote employees that are here in Texas, but maybe their company is in New York. And, we get assigned a New York EEOC investigator. That's not really that important, and it's not going to impact your EEOC investigation. It could potentially impact what happens when you want to file a lawsuit. And that would be a whole different presentation about proper venue. And if you've entered into an employment contract that has some type of choice of law, or has some type of provision that requires you to only file in the state that the employer is located in. There's a lot of different ways to look at that and a lot of different arguments, and that's kind of a different conversation. But that is an important point, that when you're going through the administrative process, it doesn't impact your ability to pursue that because it's all just administrative. Well, we thank you guys for being here today. If you're wanting to set up a consult, please reach out. Our consult attorneys are trained in all different areas of law with the firm. And so if you have an issue that you want to discuss with an attorney, we can explain to you the cost of everything. We can talk with you about what we could do for you, and then we could set you up with an attorney. Thank you for being here today, and that concludes our presentation.